We're going to start without the Attorney General, not to detain you people any longer. Once again, on behalf of the Law Society and on your behalf, I thank very much Michael Cochrane for chairing this program and working so hard at putting it together for us. And as I mentioned, Michael is now at Scott and Neal and having formerly been with the Attorney General in various capacities, not the least of which is the co-chair of the task force on the Ontario Environmental Bill of Rights, about which more will be said at the working lunch. So I'm going to turn it over to Michael, who can take us through the morning's program. Thank you.
Thank you. Thank you very much. So, warm reception. We didn't want to be disrespectful to the Attorney General, but I know from the time that I spent at the ministry that there can be some crises that come up early in the morning depending on what's in the newspapers, and there were a few items there this morning that may have caused some delay in his schedule. But what I propose to do is, if he arrives, I can always step aside and we can let him give his remarks, and then we can pick up where we left off. And what do you want to bet as soon as I start he'll arrive? What I'd like to do, just by way of introduction, is to tell you what the lineup is for the day. You've already heard about the working lunch on the Environmental Bill of Rights. And the reason we put that in was not that we wanted to exhaust you by the end of the program today, but times have been hard recently, and I think there's been a bit of a decline in some of the continuing legal education programs as a result. And we wanted to make sure that you got true value for the money you were putting into the program today. And there is likely going to be a connection between the class proceedings reform and the Environmental Bill of Rights. So it gives me, as co-chair of that task force, an opportunity to get a little bit of feedback from practicing members of the bar on how these things might be linked. So we'll tackle that over the lunch hour. And we won't use up the whole lunch hour on it. I think that we should probably have about a half-hour break in there so that people can get outside and get some fresh air. Just to give you a flavor for what we have to do today, the lineup that we planned was that I would give you an overview of the procedure. And let me underline that aspect of it at the very outset. It's a new procedure. It doesn't create any new substantive causes of action or rights that people can sue for. It's just a new procedural vehicle. So I'll provide an overview of the vehicle itself, and Tim Ray's paper, which I had a chance to read last night, it's a very good one, and Tim is a very well-known civil litigator in the Ottawa area. Actually, I articled for him years ago. Tim is the head of the civil procedure section in Ottawa, and he did a paper that describes some of the other procedural techniques that are currently available to deal with multi-party litigation. And while I would never pretend to be able to cover the subject as intensively as Tim likely would, what I'll try to do is take you through his paper so that you understand really what a class action is not. There are still other ways of dealing with multi-party disputes, and we should really keep that in mind as we deal with the procedure today. From 11 to 12, we're very lucky to have Andy Roman from Miller Thompson. Andy was a member of the Attorney General's Advisory Committee on Class Action Reform that designed this bill. I was lucky enough to be the chair of that group as well, and Andy will provide a very detailed analysis of what it means to be a plaintiff in a class proceeding. Following Andy, or at least in that same time slot between 11 and 12, we've got Beverly Moore, who is a lawyer in Washington, D.C. His firm is called Brown & Moore, but he actually runs a shop called the Class Action Reports, which is a reporting service on class actions across the United States, both at the federal level and the state level. And Bev is not just an extremely entertaining speaker. He actually has done these things. He's had massive class actions against General Motors and Ford and others, and he has the experience of the United States at his fingertips. And I know you'll enjoy hearing him speak, because I've heard him speak 3 or 4 times myself. The working luncheon on the EBR. Then after lunch, we're going to come back, and Binnie from McCarthy Tetro is going to talk about the defendant's perspective on class proceedings. If you haven't flipped ahead already, you'll find his paper is particularly entertaining. Anyone who knows him knows his flair for language, and his sense of humor has crept into the paper a number of times. So it's a terrific overview of the defendant's perspective. On a little more specialized note, we've built in a position for the Crown Civil Office in the Ministry of the Attorney General to come and tell us what some of the special considerations are when you're suing government, because this legislation applies to government like all other defendants, and I believe that the Ministry of the Attorney General is already preparing itself for the prospect that the government's going to be on the receiving end of these things. We also have a judicial perspective on class proceedings from Mr. Justice Montgomery. It's a paper that we didn't ask him to write a paper for the program because he's already very busy, but he did one anyways, and it's tucked into the back of the materials. Mr. Justice Montgomery had responsibility for the Mississauga train derailment, so he has some idea of what it means to be involved in this multi-party litigation. And I also believe he had a hand in the Air India crash settlement, so he's seen a couple of these. From 3:45 to 5 p.m., we have two things. One is we're going to zero in and look a little bit at the environmental perspective on a class proceeding. Neal Smitheman from Faskins has done a paper, and we'll hear about the relationship between the toxic torts and this procedural vehicle. And then to wrap up the day is something that has been very interesting, and the other times we've done conferences on this subject over the last 18 months, is to just have a panel discussion about some of the new things that lawyers are going to have to think about when they try to take these actions on. There are some very interesting ethical problems that American lawyers have had to confront over the years when representing a group of people that can number in the tens of thousands, hundreds of thousands, people who are technically your client, but you'll never meet them, and they may not even know that you're acting for them. So there are all kinds of unique little problems that come up using the procedure, and I think the panel at the end of the day will give us a chance to hear from people who have a lot of experience, not the least of which is Ian Scott, who was the Attorney General that really kick-started this whole reform movement in class actions. We also have Ken Howie, who has some information for us on the relationship of contingency fees to the practice of law, and in particular to class proceedings. And we also are going to have Mr. Justice Montgomery on that panel, so we can find out what judges think, what the judges will think about the procedure, as well as we're going to try and get Bev Moore to stay a little bit late so he can also sit on that panel and tell us what some of the experiences have been in American jurisdictions. So that is the overview of the day, and I suppose that where we could start off is I can tell you, if you want to go to Chapter B of the materials, we can start off by talking about the big picture. What is the procedure all about? Why is it different from regular litigation? Where do we try to keep the parallels sound? We tried to make sure in designing this procedure that it didn't depart from normal rules of civil litigation unless it was absolutely necessary. That was one of the starting principles for the design of it. So let me just say by way of introduction on it, and I hope I don't preempt anything the Attorney General says if he gets here, is that the timing for this is as follows. The legislation, and there are two pieces, Bills 28 and 29, have received first reading and second reading. They have been considered by the Standing Committee on Administration of Justice. They do a clause-by-clause analysis at that stage of it, and it was approved and referred back to the House for third reading. Now, the bill is, if I remember correctly, number one priority for the Attorney General in this session, which means it'll get third reading and royal assent likely before the end of April. That means that all that's required is a proclamation date. It won't come into force until proclaimed. And there's a little bit of work that has to be done preparing some regulations and some other administrative procedures within the ministry, but there isn't any reason why it couldn't be proclaimed late summer or early fall, which means it would be available after that. And as we get into the procedure today, you'll see where some of the little regulatory wrinkles that have to be worked out come up. That's where it's going. Where it came from is described in a press release that's attached to my paper called a Class Action Background, or I wrote that when I was at the ministry. It provides just an overview of the procedure, but it also tells you, and I don't propose to dwell on this at length, it tells you where the procedure came from. It was a bit of a unique idea that Ian Scott had, that we would actually get the stakeholders, the people who would most likely be affected by a reform, to sit around a table and develop it. And that means bringing the Advocate Society representatives in, people from the Canadian Bar Association, people from Canadian Environmental Law Association, Energy Probe, Canadian Manufacturers Association, Federation of Independent Business, Chamber of Commerce, and others. Insurance Bureau of Canada, for example, sat at the table. We thought that it wouldn't be right to undertake this magnitude of a reform unless we actually knew what people thought about the procedure and sat right at the table and told us. Now, the amazing thing about the process was that they came up with unanimous recommendations. There wasn't a business sitting on one side of the table saying, we don't think this is the right procedure for business. They actually saw their stake in the procedure and supported the recommendations that were incorporated in Bills 28 and 29. Now, that, as I say, was a unique start for development of a big law reform. We're trying to recreate that success in the design of the Environmental Bill of Rights. And it's really mediation of public policy disputes that's going on now inside government. And that's where this reform came from and where the Bill of Rights is coming from. The key players get to decide what the reform should look like. Now, the unique thing about having that kind of approach to reform is that you're able to get three-party support when you go through the House. And one of the points that has been made in the past is that this is a reform that was started, in a sense, by Roy McMurtry back when he started the Law Reform Commission investigation into class actions. It was picked up and pursued by Ian Scott, and it's being ushered through the House by Howard Hampton. So it's a unique bill in that sense. Everyone seems to recognize the value of it. So those are the reforms, or sorry, those are the origins of the reform. You may want to spend some time taking a look at a 2-volume report that's available for free from the Ministry of the Attorney General. It's the report of the advisory committee that developed the legislation. It gives you an annotation and a flavor for why certain provisions were developed the way that they were. But what I really want to talk about this morning is what the procedure is all about. And what I'd like to try and do is give you the overview that will allow you to get the big picture of how this is used. And it's not a case of just starting into a procedure and sort of working your way along. There are certain things that happen at the end of a class action that you have to think about at the beginning of it. And it really is the kind of procedure that you have to roll around a little bit, break apart, and put back together before you get a feel for some of the nuances in using it. The starting point is Rule 12. Rule 12 used to be Rule 75. Back in 1881, Rule 75 used to have almost exactly the same wording. You'll see from Tim Ray's paper that the current Rule 12 has not evolved significantly over time. Rule 75, the predecessor to Rule 12, went to the Supreme Court of Canada in the Nakin decision, which involved the forensas. It was unsuccessful. They said that a class action pursuant to Rule 75 wasn't the right vehicle because the scantiness of the rule couldn't support the kind of complex litigation that was being contemplated by this forensa action. So the comment was made that if something was going to happen in the area of class actions, it was going to have to be legislative, and that's where the bill came from. Now, what I propose to do is I said my paper was an A to Z guide, and I've just broken the paper up into a bunch of categories of literally A through Z. So beginning with B, the meaning of a class proceeding, the definition that the advisory committee began to work with is the one set out in the first paragraph, that it's an action brought on behalf of or for the benefit of numerous persons having a common interest. And that, in a nutshell, is it. All of the substantive barriers that existed in the past to this type of representative action, we will see as we go through the procedure, will fall by the wayside. And it all comes back to this very simple general statement that where you have numerous people who have a common interest, if you can find one person to speak on their behalf in a court, you've got you've taken the first step towards a class proceeding. Now, the American expression is class action. In Australia, they call it grouped proceedings. Australians are also undertaking class action reform right now. Are they, see here? Yeah. Just tell them to wait for a few minutes. He will? Oh, that's interesting. Okay, what I'll do then is, rather than pick up with the B for the meaning of a class proceeding and what it's not, why don't I step aside for a minute and you can hear from the Attorney General about some of what really the point of the exercise was in bringing this kind of reform forward. And if I'm not mistaken, James Spence, who's the treasurer of the Law Society, is here to introduce the Attorney General. And I was kidding Mr. Spence before we started this morning that I didn't know what was keeping him up later last night, reading the papers that other panelists had provided or reading his CV, because he has a long list of very heady accomplishments, not the least of which is that he's the partner in the Toronto law firm of Tory. He's the director of the Federation of Law Societies of Canada, a member of the councils of the Canadian Bar Association. He has numerous professional activities, including being a lecturer and speaker in the Law Society, CBA programs. He's a co-author of a guide to the Investment Canada Act, co-editor and contributor to the Foreign Investment Review Law in Canada, chairman of all kinds of boards and advisory committees. He's a panel member of the Private Court, and he has numerous other charitable activities that he's involved in. And we should never forget where we all begin. He was called to the Bar of Ontario in 1968. And this is Mr. Spence.
Thank you. I think the plan was a little different, but I'm happy to be here to introduce the Attorney General. I appreciate Michael Cochrane's remarks. Unfortunately, he got the wrong CV. But I am interested that he was prepared to go through all of that stuff. I tried to persuade him not to, but I obviously was not very convincing. He did not, however, mention that I once owned a Forenza. So I do regard this program as timely and important, and we are pleased and honored to have the Attorney General, Howard Hampton, here to address us about the new Class Proceedings Act. I should mention that under the Law Society Act, the Attorney General is the guardian of the public interest in respect of matters relating to the legal system in Ontario, and the Law Society has continuously enjoyed a very cordial and productive working relationship with Mr. Hampton and the members of his department in matters relating to the legal system. It's a great pleasure for me to welcome the Attorney General to Osgoode Hall once again. Mr. Hampton.
Michael? Thank you very much, Jim. I'm sorry to hear about your Forenza. I'm sure that will all be taken care of in due time. Ladies and gentlemen, thank you very much for the invitation to be here today. I welcome the opportunity to open this program with some thoughts on the goals and the purposes of the important class proceedings reform. When I was sworn into the position I now hold in October of 1990, I was already aware of the serious need for increased access to justice for the people of Ontario. The last year and a half has indeed underscored my appreciation for that need, and my goal to find new and more affordable ways that justice can be delivered expeditiously. For these reasons, I recognize the importance of this reform that was initiated by my predecessor, Ian Scott. Now, as you're aware, Ian Scott had created an advisory committee on class action reform that was designed the legislation that you will consider today. And Michael Cochrane was part of that committee, as you're also no doubt aware. That advisory committee was made up of representatives of a broad cross-section of our society, and remarkably came up with a unanimous consensus for reform. That's quite remarkable, especially if you view it from the perspective that we have within the ministry. Finding a unanimous consensus is something that happens about every 20 years. And if even then, you're probably fortunate. The Class Proceedings Act and the Law Society Amendment Act are awaiting third reading and royal assent by the legislature. It is our expectation that these bills will be dealt with before the end of April, with proclamation around the end of the year. And assuming all goes according to plan, we should speculate now what this legislation will mean in terms of access to justice for the residents of Ontario. I'm going to leave the procedural nuts and bolts of this vehicle to the experts that follow me, but I would like to use this opportunity to identify some of the barriers that litigants face in our justice system and highlight the ways in which I believe this legislation will lower or remove some of those barriers. I think we would all agree that there are 4 types of barriers that litigants face in this field. First of all, substantive barriers. Secondly, procedural barriers. Thirdly, evidentiary barriers. And finally, financial barriers. With respect to substantive barriers, we all know that courts led by the Supreme Court of Canada have narrowly interpreted the existing rule of court for class actions. If the plaintiffs were complaining of a breach of contract, it was necessary for all potential class members to have identical contracts. If the class members were seeking damages, the possibility that damages had to be individually assessed for each of them prevented the class action continuing. These substantive barriers effectively chilled class litigation in Canada, with the exception of Quebec. And you know that Quebec has had class action procedures since 1978. Procedural barriers. Procedural barriers were encountered by litigants who had similar claims because the existing rules of civil procedure were not developed with a view to litigation by one person on behalf of perhaps thousands. Special rules for discovery, for notice to the class members, and for participation in the class would be needed if the class action were to move through the courts with any fairness and efficiency. Evidentiary barriers. Litigation on behalf of a class also poses interesting and difficult evidentiary problems. Reliable statistical evidence could be valuable in class actions and would reduce unnecessary evidentiary and administrative burdens for litigants and for courts. The problem, as you know, is that Canadian courts have generally taken a restrictive approach to the admissibility of statistical evidence. Finally, financial barriers. Financial barriers, of course, prove to be the most fatal for most class actions. As you're aware, an increasingly small segment of society can afford to retain legal counsel to bring important claims in our courts. Finding sufficient funds simply to retain a lawyer could often discourage a plaintiff, particularly when the plaintiff was expected to litigate on behalf of many persons who were in the same tight financial situation. In addition, assuming an affordable counsel could be found, the disbursements incurred in marshalling the evidence for a claim on behalf of many persons could be discouraging to even the wealthiest plaintiff. Finally, what plaintiff would be prepared to litigate on behalf of his neighbors when the risk of losing the lawsuit could result in financial catastrophe for that representative plaintiff? The picture that emerges for litigants in a class action is a very dark one, where substantive, procedural, evidentiary, and financial barriers conspire to discourage even the most worthwhile and meritorious litigation. As you learn about this procedure today, you will see the many ways in which these barriers are removed or lowered. For example, with respect to substantive barriers, the Class Proceedings Bill states clearly that the requirement for identical contracts or the need for individual damage assessments shall simply not be a barrier to a class action any longer. On the procedural front, a sophisticated and comprehensive procedure is put in place to meet many, if not all, of the needs that litigants will have in these cases. With respect to evidentiary needs, special rules are provided to ensure that the new forms of evidence are before the court. Finally, on the financial front, a combination of reforms involving contingency fees and a class proceedings fund should contribute significantly to the coming forward of the right type of litigation under these reforms. On this last aspect of the reforms, the Class Proceedings Fund, the significant contribution of the Law Foundation of Ontario, must be gratefully acknowledged. The Law Foundation of Ontario has very generously contributed the sum of $500,000 to assist representative plaintiffs with disbursements in class proceedings, and in some cases to offer indemnification for adverse cost awards. Without this contribution, it is difficult to imagine the reform having the potential impact that it now promises to have. In closing, I think this procedure presents a challenge for the practicing bar. The improved access to justice that it promises to deliver will only be meaningful if the legal profession learns to use this new tool efficiently and effectively. The complexity of the litigation, the unique relationships that you will now have with clients, and contingency fees all present new challenges to you as civil litigators. I know it is a challenge that the legal profession in Ontario can and will meet with its usual vigor and imagination. We have great hopes for this legislation. It has taken a lot of work under the guidance of my predecessor, Ian Scott. It has taken a lot of work over the last 18 months to bring it now to fruition. We believe this will be a significant step forward for the people of Ontario. I want to say, to close, thank you again for the opportunity to be here. I hope that you enjoy the balance of the proceedings, and we look forward to your comments once the litigation is in place and once you're all out there using the legislation and working hard on behalf of your clients. Thank you very much. Ordinarily, I would say I'd be pleased to answer some questions, but I have 15 minutes to make it to my next stop. Michael is here, and since he was the one who was most responsible for finding this unusual state of consensus, he is perhaps the best person to answer the questions anyway. Thank you very much.
Surprised he didn't mention that he and I used to play hockey together in law school, but I guess speechwriters didn't have time for that. Where we left off was talking about this overview of the procedure itself, and it's funny, as the Attorney General was speaking, I was thinking about the effect that working on this had on me. I found I couldn't even take the subway without thinking about, gee, I wonder if that would be a class action. Because once you start reading about cases, you know, you hear about in Quebec, for example, there was an illegal transit strike, and everybody who had a monthly pass on the transit system was in a class. In the States, there have been some very unusual ones. Everyone who was illegally charged taking a taxi cab in a particular city over a period of time. It can really move from the very creative to the arcane. But hearing Jim Spence even mention his forenza, I don't think any lawyer will ever hear the word forenza for the rest of their careers without thinking about where Nakin went and the impact that that car had on law reform. But in any event, don't be surprised as you get immersed in the procedure that you start thinking about applications in your own practice. And this may be the biggest challenge for us all, is trying to think as the person sits in front of us, saying, I was injured in a particular way, I had this particular loss, of whether you're actually looking at the tip of an iceberg. Is this person actually a representative of a huge class? And we're going to talk a little bit this afternoon about how you broach that subject with that individual. So in any event, just returning to my overview with B and C, the meaning of a class proceeding and what a class proceeding is not. I was talking about the American experience of calling it a class action. In Ontario, we call it a class proceeding because that dovetails more neatly with our rules. In Australia, they call it a grouped proceeding. Their procedure is a little different from ours, but they expect to have theirs passed by the end of this year as well. On what a class proceeding is not, I only underline here, and we can spend a few minutes on it when I get to Tim Ray's paper, but don't forget about joinder, consolidation, the trial of actions together, and the possibility of having a test case. Because you're going to see when we look at the certification test that you're going to be required to tell the court why the class action is the preferable way of solving this problem, which means you're going to have to be able to explain why it isn't, why it wouldn't fit neatly under one of these other procedural devices that's available. Another little part that you should be aware of that you may not think about at the time that you're trying to determine what a class action is not, you should also be aware of Section 37 of the legislation that says what the Act does not apply to. So these are also things that are not suited to class actions. And there are three categories. The first one is that if you've got the ability to bring this claim in a representative capacity under another Act, you don't get to use this Act. And there are 5 or 6 pieces of legislation in Ontario that already contemplate representative proceedings. The best example is Section 119 of the Landlord-Tenant Act, where a group of tenants can get into an action. They can't use the Class Proceedings Act because they have that available to them. A proceeding required by law to be brought in a representative capacity cannot be brought under this Act. And one that may turn out to be quite important for some litigants is a proceeding that was commenced before this Act comes into force cannot be reconstituted under this legislation. I've already had a few phone calls from people even in this room who've asked me, I've got this action underway, or I'm thinking about a particular action. Should I bring it now? Should I wait? Should I stop? And you may have to think very carefully about your decision to start an action before this is proclaimed. D, just very quickly, is the relationship between class proceedings and the rules of civil procedure. If the Act doesn't say what the procedure is, then the rules of civil procedure govern. And there are some little points where you'll see they fit together, where it was necessary to make some specific departure from the ordinary rules, for example, with discovery and getting notice out to classes, members of the class. We had to provide some special procedures, but the rules govern. The representative plaintiff, I can hardly wait to meet the first one, because this is going to be one brave individual who wants to get started in this kind of litigation. The Attorney General mentioned that some of the barriers to this kind of litigation, especially the financial ones, have been lowered, but they haven't been eliminated. And to find someone who's prepared to come forward on behalf of a class of people and agree to retain a lawyer, instruct him or her on the conduct of this litigation, develop a plan for taking it through the court system, to manage this potentially huge piece of litigation on behalf of lots of people that he or she may never meet. And as I said before, people who may have no idea that this action is underway, is going to be quite a responsibility. And as the Attorney General mentioned, it's going to present some challenges to the way that we communicate with the client, because it's going to be difficult enough to tell them what it means to be a representative plaintiff, to describe the financial consequences to them. It's also going to be quite unique to manage as a lawyer this client and this group of people that he or she speaks for. Now, the representative plaintiff will come either from one of two categories. This will be someone who comes forward and says, I'm here on behalf of all of these people who were harmed, everyone who lives in the Mississauga area, who was displaced or harmed by the derailment of this train, and I want to start the action on behalf of the group. Another kind of representative plaintiff is, let's say, for example, one of many users of a Dalcon shield, and she goes into the system as a plaintiff, and the defendant points out that there are in fact 5,000 or 6,000 similar plaintiffs out there with individual actions, and the defendant asks the court to turn one of those individual plaintiffs into a representative of the larger class. So it may be possible that someone is appointed as representative plaintiff not because it was their wish, but because that's what the court thought was the best way of managing this piece of litigation. The third category of representative person before the court is the possibility of a representative defendant. And this is the situation where there are many claims against many defendants, and one of the parties, could be a defendant, could be a plaintiff, says to the court, this litigation may be more efficient if you appoint one of the defendants to represent a class of them. And an example of this could be something like pharmaceutical companies that distribute a particular drug. It's impossible to determine who sold which drug to which doctors or for which distribution, but it is possible to figure out what the market share was for a particular vaccine. And because the plaintiffs are suing a whole group of defendants who distributed this particular vaccine, they may say, the court may agree, that it would be easier to have one of these defendants defend the whole piece of litigation on behalf of all of them because their defenses are so similar or the issues are so similar. So you may have representative plaintiffs, you may have representative defendants. So don't forget about, and this is one of the interesting bits and pieces that the corporate representatives had in the advisory committee, is that the possibility that there were some efficiencies for defendants in the litigation. How's the class proceeding started? Same way all other actions are started. Notice of action, statement of claim, and or notice of application. Now you may wonder, with this kind of a potentially complex litigation, why would a notice of application be tolerated? It may be that the action is put in that form to obtain settlement or approval by the court. In other words, the claim exists, discussions are underway, a settlement's arrived at, and there's a need to get it approved by the court, and you simply want to use the application procedure to achieve that. One little administrative piece that I mentioned that the ministry still has to sort out is the prospect that people may come forward in all different parts of the province saying, for example, somebody up in Ottawa may say, I found a representative plaintiff for a particular class, people who are injured by a particular kind of product, exploding pop bottle. Someone in Thunder Bay has the same kind of client sitting in front of them. They both go into the system with class actions arising out of the same issue. What's been suggested to the ministry is that they need to create some kind of central registry, not unlike the central divorce registry, to make sure that there aren't conflicting or a multiplicity of class actions underway around the province. That has to be set up, and I don't think it's going to be that difficult in the early stages. As for service, the normal rules apply. There's no special service requirements with the class proceeding. Certification is the key. This is what makes, one of the things that makes this kind of proceeding different from all others. You can't simply because you've got a plaintiff, go into the system and use up all kinds of judicial resources or legal resources. You have to get the court's permission to be in the system as a class action. And in order to get the permission of the court, you have to have met a 5-point test. And the 5-point test is, as part of an overview, is that you have to have a cause of action, you have to have 2 or more people in that identifiable class, one of whom is represented by this individual that's the representative plaintiff. You have to have a common issue. You have to have have to be able to demonstrate to the court that the class proceeding is a preferable way of solving this particular problem. That's where I mentioned distinguishing it from other procedural techniques. And finally, and this is where the representative plaintiff and plaintiff's counsel are going to have some creative work, is you have to be able to demonstrate to the court that this particular plaintiff, this representative plaintiff, fairly and adequately represents the class and has a plan for prosecuting the action. In other words, the plaintiff just can't come forward and say, I'm one of the group. They have to say, I'm one of the group, and here's who's in the group, to the best of my knowledge. Here's how I propose to get notice to them. Here's how I propose to manage the action. Here's my critical action plan. I see pleadings being completed in this form, at this point in time, with this kind of management, and so on. So you have to have a plan in order to get certified. And you have to have a representative plaintiff who isn't in conflict with other members of the class. In other words, it can't be that this particular individual is somehow inhibited from speaking on behalf of other people in the class. Now, the experience in the States and the experience in Quebec has been that this is the key event in the class proceeding. The vast majority of them settle after certification. So the court has quite a bit of discretion about whether to certify, and it also has some discretion to say, we don't have enough information in front of us. These pleadings aren't tight enough. There may be a need for more evidence. Let's adjourn and get this sorted out. So the certification motion may not simply be a one-shot event. The other thing that you should understand about certification is that if you don't win, you're not simply shut out of court. It may be open to the court to say, this isn't suited to a class action or class proceeding. It should be an individual claim, and I'm simply going to make, instead of a certification order, an order amending the pleadings so that it can carry on as an individual piece of litigation. And the thing that you'll have to keep in mind at this stage is the consequences that that has for other people in the class and their limitation periods. If you take a look at the provision dealing with limitation periods, which we'll come to, there's a connection there because limitation periods are suspended by the commencement of a class proceeding, and they start to run again when certain events happen, but we'll come to that. Now, the Attorney General mentioned the substantive barriers to class actions, and when we talk about substantive barriers, we mean that the court insisted that if everybody had an identical contract, then you could be in a class. But if you had a need for individual damage assessment, you couldn't be in a class because that was too complex for the court to manage. Section 6 simply repeals that and says that those things in and of themselves should not be a bar to having a class proceeding. And there are some other grounds that are identified as well. And Mr. Justice Montgomery is going to touch on this in his paper where he talks about, he doesn't use the term, but this is what they did in the Mississauga train derailment, is they had subclasses. Different people in Mississauga had different kinds of damage. There were some people who were completely dislocated. There were some people who were actually harmed. They have different kinds of claims. The fact that their claims are different doesn't mean they can't be in the same class. It just means they may be in a subclass within the larger class. So you may want to spend some time examining Section 6. The other part of certification is what the certification order will say, because that's going to be the starting point for everything that happens after the action is certified. At the bottom of page B7, there's a list of things that the certification order must do. It must describe the class. It must state the names of the representative parties. Maybe you'll have a representative plaintiff and a representative defendant. State the nature of the claims and defenses asserted on behalf of the class. which will be relevant for the issue of res judicata in other claims that may come forward later. State the relief sought by or from the class. Set out the common issues. What's the problem the court has to deal with that affects all of these people? Specify the manner in which class members may opt out of the class proceeding and a date after which class members may not opt out. We'll come to that feature in a moment, but you'll notice on B8 and B9 of the paper that there's a little bit of discussion about the role of subclasses, the possibility of decertification of the claim later in the action. Just meeting that 5-point test doesn't mean you meet it for a day. You've got to keep meeting that test, or you run the risk of being decertified. Opting out is an important feature because this is what makes this kind of proceeding different from other forms of litigation. This representative plaintiff comes to the court and says, I speak on behalf of a group. He hasn't consulted with that group, or she hasn't consulted with that group. They just say, I represent them. We had a choice in designing the procedure about whether we'd have an opt-in model or opt-out. Australia faced the same choice, and they've gone the same route that Ontario has of having opt-out, and that is that you're presumed to speak on behalf of the group unless the person does something to get out of the action. In other words, they have to take a concrete step to remove themselves from the class. The alternative was to have an opt-in, where the person comes forward and says, I speak on behalf of the class. Anybody who wants to join me in this litigation can sign up. We elected for the opt-out model because it maximizes participation in the class. And the logistics of requiring people to sign up for a class proceeding would mean that in some cases the expense of simply getting the class together would far outweigh the efficiencies that you were hoping to gain in starting the proceeding. So opting out is an important feature. And just to go back to that order for a moment, because we don't want to have people in the class sitting on the fence, the court is going to say in the certification order, if you want to get out of this action, you have to get out by a certain date. If you don't get out by that date, you're in. Now, there are some provisions that allow for leave or relief from that hard and fast rule, but the presumption is going to be that after that date, you are in the class proceeding for the full duration. The reason that kind of imposed solidarity is needed is that after a certain point in time, this thing has to proceed as a class. You can't have people coming forward and saying, I don't like the way the discoveries went. This first day of trial gave me the shakes, I'm out. So the next logical step in that is that if the certification order is telling people that they have to get out of the action by a certain point in time, then you'd better be able to tell them about that. So the bill provides three general categories of notice. Notice out to the class, notice to the world about this litigation. Once you're certified, there's an obligation, unless the court says otherwise, to get notice of this proceeding to the people in the class. And that can be achieved in a variety of very creative ways. It may simply be that if you know everybody in the class, let's say you've got their warranty cards, from now on people will always send in their warranty cards, because that may be your membership in a class action if the product turns out to be defective. But let's say all the warranty cards are available and all their addresses are on the warranty cards, and the plaintiff says, I need to get notice of certification to all the people who are in the class. It may simply be sending a letter to people who have already provided their address in some other way. If it's a utility, for example, let's say I better not mention names of companies. Every time I did, once I was giving a talk and I said Hoover vacuum cleaners, and sure enough, general counsel for Hoover's sitting in the front row. But let's say a cable company overcharged people for cable television services, knowingly or accidentally. People paid, and then it's discovered. It may be possible to have the cable company send the notice to people about the class action, because they're in the best position to get notice to the class. So with the bill, people open it up, and instead of cheap gas furnaces or some other product you're being sold, there's a little notice in there that there's a class action underway on behalf of all cable subscribers in the Metro Toronto area. It may be leafleting. that's necessary. There may be, I saw one in Toronto here, there was an advertisement in the subways posted up above the seats for anyone who was, had a particular kind of loss. There was a huge ad in the Toronto Star about 7 or 8 weeks ago on behalf of a group that had a class action in the state of Ohio for the malfunctioning heart valves. And the notice was not that certification had occurred, it was notice that they were about to settle the case, and they needed to know what people thought about the terms of the settlement, which had 3 or 4 pots of money involved. The first pot was $80 million, the second one was $70 million, and the third one was a percentage of those 2 previous funds to compensate the class lawyer. So it was a very extensive notice. If anybody ever wants to see a copy of it, I have it available. But the point that I want to make here is on notice is that the Act contemplates the possibility that there's going to be a need, firstly, to get notice to these people once it's certified. Secondly, once the court gets to the point of actually dealing with this common issue or the individual issues. And thirdly, there may be a need to get notice out from time to time about offers to settle, about some, maybe about a decertification. Maybe there's been some meltdown in the litigation that's triggered the need to tell people that it's being conducted in a different way. All of those things are contemplated in the Act. All of the procedures are set out, and even some of the alternative methods of getting notice out are described there. The point of the exercise is to give the court and the parties maximum flexibility in getting notice out to people in the class. Role of the court, Mr. Justice Montgomery is going to speak about at length, but as he's going to underline for you, and I don't want to preempt his remarks too much, if you thought case management was interesting, this is a whole different exercise. This has one judge looking after one class action until trial. Very, very extensive authority given to the court to manage the litigation, to get people to do things, to facilitate this getting through the system. And I'll let Mr. Justice Montgomery spend some more time on that. Discovery. You can imagine the horrifying prospect of having to discover everybody in a class of 10,000. There's one case, I mentioned in the paper, in Texas. They tried to get a class action going on behalf of 60 million people. It was against General Motors, I think, and their fear was that each one would want $1. I think that it wasn't certified because they said that was too many people. But I think they broke it up into a number of smaller class actions, $1 million each. But the point on the discovery is that we couldn't have just everybody in the class available for discovery because we know what defendants would do. They'd discover them all. And what we say in the legislation is that the representative plaintiff is discovered. If you need to go any further or deeper into the class, you have to get permission. It's not that it's going to be denied, it's just that you'd better be able to demonstrate that you need to get access to these other people. And there are some factors set out that will guide the court in making the decision about whether or not they want to give leave. Common issue and individual issues are really the way the action breaks into 2 big pieces. And that is, the common issue is generally the liability. And the individual issues are the need, or the possible need, for the assessment of individual damages for members of the class. Now, in some cases, you may not need any individual assessment. Mr. Justice Montgomery is going to talk about aggregate awards, where you can simply say 10,000 vacuum cleaners malfunctioned. It's a $25 part. We know the representative plaintiff speaks authoritatively on behalf of the 10,000 people who lost the $25 part. We can simply do a mathematical calculation to get the amount of the judgment. There wouldn't be a need to have individual plaintiffs or individual representatives of the class come in to prove that kind of award. Matter of fact, we want to do everything we can to facilitate the proof of it without people having to come to the court to do that. It might be different, though, if somebody in that class, because their part malfunctioned, their house caught fire and burned down, and they need to have some kind of assessment of damages, or their child was injured. So you can see we're in a class, there might be some people who need a damage assessment and some who might not. The common issue might be the same. That's a part that didn't work, that malfunctioned, that caused harm. That's the common issue. The consequences of that malfunction are the individual ones, and the procedure set out in the Act contemplates dealing with both. For judgments, I've got two categories here. One is assessment and one is distribution. There's a very big difference between being able to assess the damages that the people are owed and actually getting it out to them. For the assessment, we've tried to, in the procedure, facilitate the court assessing damages in the easiest possible way. I mentioned this one of the aggregate assessments. It may be possible that while you can't do an aggregate assessment, that there might be easier procedural ways of getting people to send their proof in. Some American class actions have used, you have a form you fill out. If you're a member of the class, you had a particular loss, they develop a form that's approved by the court, approved by the parties, they send the form out, people fill it in, what their loss is, and they send it back, and somebody sits and checks off the form to figure out exactly what you're entitled to. And the assessment of the damages can be facilitated quite a bit by not requiring people to actually make an appearance at a courthouse. Now, as I say, distribution is another matter, because if the court says this group of people is owed $750 million, just handing a check over to the plaintiff's counsel and saying, now you have to get this out to the people in the class, you may spend the rest of your career answering the mail or making sure that the checks get out to them. The court has a variety of methods available to it to get the money out to the people. It may be, for example, on the cable TV example, where there's an overcharge by a utility or some other service, the court can simply order that utility to lower its fee by the same amount for the equivalent period of time so that that money gets back out to people in the community. There's no need to have checks issued. Just like Bell Canada may be ordered to lower its long-distance rates for a particular period of time. That's a successful result in a class proceeding. Now, the important thing to note here is that that's just one way the damages can be distributed. There are lots of other ways. It may be necessary for the court to order that somebody hold the money and that it be paid out as people send in forms claiming it. General Counsel for Procter & Gamble, Bob Anderson, who was on the Class Action Advisory Committee that developed this, mentioned one day getting a telephone call from somebody in the States who said, "You want to be in a class action?" Sure. What does it cost? Nothing. You're in. Procter & Gamble was in a class action. He hung up the phone, forgot about it. A year later, he got a check for $70,000 from somebody he'd forgotten all about, because the class action had gone through, they looked after his claim, his name and address was on a list, and a check simply was sent out to him. So it may be that the court will order some very creative methods of distributing these kinds of large damage awards. The possibility of a rebate, of an abatement, vouchers for coupons for savings on products. This taxi case I mentioned, I think there was one in Philadelphia and one in California. There was an overcharging, fraudulent overcharging by a taxi company, a couple of dollars, number of miles. The court said, lower your meter rate for the same period of time to get the money back into the community. A reaction from some people when they hear that is, well, what if that guy didn't take that taxi? What if he didn't actually lose money? Somebody's going to take a taxi and they're going to get the benefit of a lower rate even though they're never out of pocket. That's part of the sort of rough justice of a class proceeding. There may be people who are compensated who wouldn't otherwise be. There may be people who are owed compensation that don't get it. Somebody's visiting Philadelphia from out of town and they were overcharged in the taxi ride. They never go back to Philadelphia. They have other reasons for not going back there. But it's possible to get the court to simply order that this money that was fraudulently taken or improperly taken from a community be injected back into that community, provided it's likely that people who lost will receive some benefit. Evidence is something that the Attorney General mentioned. When you're dealing with groups that are this big, you may need to figure out the entitlement of the class not by polling individual members or surveying individual members. You may need to take a cross-section sample of the class and say, this sample is reliable enough for us to be able to do a calculation, my lord, that will see the right judgment calculated for the class. And you're going to have to spend a few minutes reading the Section 23 of the bill that facilitates the use of this kind of statistical sampling evidence for the court. Mr. Justice Montgomery will touch on that point again. T, an important point, is the settlement of the claim. Can't be settled unless you have the approval of the court. Can't discontinue it, you can't abandon it, you can't settle it unless you have approval of the court. You'll also notice when you look closely at some of the provisions in the bill that not only can you not do that after it's certified, you can't settle it without court approval after it's commenced. Commenced or certified, you have to have court approval for settlement. That's to avoid what we heard rumored was going on in the States, that people would issue the claim saying, I'm here on behalf of 14 million people who had a particular overcharge on some kind of policy. And if you settle with me before certification, we can all go our separate ways and no one has to know. In order to protect the class, we need to have even that kind of settlement approved by the court. U section on page B16 talks about limitation periods and the effect that the commencement of the proceeding has on individual limitation periods for members of the class. If a member opts out of a class proceeding, the limitation period runs against him or her again. If there's an amendment that excludes somebody from a class proceeding, let's say they have a conflict, limitation period will run against them. If the class proceeding is dismissed without an adjudication on the merits, limitation periods start running again. And the only other caution that I mentioned in my paper is that some members of the bar are aware of this. If anybody's not, the Attorney General's office is coming forward with a new Limitations Act, comprehensive, uniform limitation procedure. And we may see that very soon. And the relationship between that Limitations Act, which sets standards for example, 2-year limitation periods for a lot of claims, and ultimate limitation periods and things like that, 30-year ultimate limitation periods. The relationship between that and a class proceeding is something we're probably going to have to spend some time thinking about. It's available free from the ministry if you want to give them a call. Appeals, the only point I make here is a part just of your overview is that because the certification order is the key one, there are different rules for whether you win or lose that. If you get certified, the defendant can't appeal that without leave. If you lose it, you can appeal. You don't need leave. So there's a little bit of an extra measure there for plaintiffs trying to get certified. Accounting to clients, 29 sub 4, it's possible when the court endorses the settlement of the proceeding or makes the judgment that they're going to order you as representative plaintiff or counsel for representative plaintiff to actually account to the class for what you've done. And it may not mean giving everybody a copy of your statement of services, but it may be that you're going to have to develop some kind of concise explanation of what you said was going to happen in the action, what happened, and what the outcome was, and how the money's being distributed. So it's more, this goes back to this unique relationship you're going to have with this group of people and the need to communicate with them. Costs, fees, and retainers I could spend probably the entire day on, but you have to understand 3 things about costs on the overview. Contingency fees are going to be in Ontario because of this Bill 28. Class proceedings have their own special contingency fees right in the Act, just for class proceedings. The second part is the Class Proceedings Fund that the Attorney General mentioned. Very unique and generous contribution by the Law Foundation. And the third part that you have to understand is really how they all combine to lower the financial barriers to class proceedings. And the Attorney General mentioned that, you know, for someone who wants to be a representative plaintiff, the prospect of going and hiring a lawyer for themselves, never mind for a whole class of people, is pretty daunting these days. Then they've got to come up with disbursements to get the action underway. Never mind just for themselves, they might have to hire an expert. They might have to contemplate this sampling of the class. They might have to get notice out to everybody. Even by mail, that can be expensive. A newspaper advertisement in every Ontario daily, one day, about this big, is about $40,000 for one ad. If you had to run it 3 or 4 times, the disbursements alone can be pretty intimidating. The third part is the one that most people worry about. What if I lose? I'm personally on the hook for the costs. So what we tried to do with contingency fees and the Class Proceedings Fund is eliminate or lower those barriers. The risk of hiring a lawyer, or the expense of hiring a lawyer, is minimized by the contingency fee arrangement. This Class Proceedings Fund is going to address the other two concerns. This fund has $500,000 in it. A representative plaintiff can apply to that fund to get assistance with disbursements. Not fees, just disbursements. If you get some help from the fund for those disbursements, you enter into an agreement with it that if you win, or if you have a successful settlement, you're going to give back some of your recovery to the fund to keep it liquid. We talked in the advisory committee of 5, 6, 7% of your judgment is going to go back, regardless of how much you took out. You took $10,000 out of the fund for disbursements, but you get a $750 million judgment. 5 or 6 or 7% is going back into that fund to help future representative plaintiffs. Now the other thing is, if you use the fund for these disbursements and you agree to give that money back, or that you agree to give the percentage recovery back, and you lose, the fund will indemnify you for the adverse cost award. It's a huge benefit to a representative plaintiff. It's the big worry is alleviated. Now, most people say, well, I guess every case I'm going to automatically apply to the fund. Well, you're going to have to balance the potential cost, that 5 or 6% that you're going to turn over, against the value of the disbursements, against the value of the adverse cost award security that you may get. So you'll have to spend some few minutes thinking about the relative expense of using the fund. If you only need $5,000 or $6,000 from to get your class action up and running, don't go to the fund, because you may not you may pay far more than $5,000 or $6,000 for using it if you're successful. So a lot of it goes to the merit. The other thing is that the fund, which is going, this is the regulatory structure that has to be set up still, is going to take a look at the merits of the case. So you won't automatically get assistance with it. They've got a tighter screen than the court has at certification. So we're going to spend a little bit of time talking about the fund later on. The only thing I want to mention is that on the fee side, legal aid does provide group certificates. And at page 18 and 19, I talk about the criteria that the legal aid people use to assess whether or not you're entitled to a group certificate. It's a possibility. Other considerations I mentioned in category Z is that there's a whole field, because one of my other areas is mediation of multi-party disputes. There's actually a connection between the two in the States, where they say once you get certified and you've got this big group of people, you may have a whole bunch of defendants, you may have a very good representative plaintiff, lots of lawyers. These things are very well suited to sitting down and having a multi-party negotiation on what should happen after certification. And it may just be that you pick off some of the issues, you may pick them all off. But there is a role for the mediation of these kinds of disputes post-certification, I think. And as I say in the second paragraph of that category Z, there are a whole bunch of other considerations, logistical and otherwise, that we should think about I'll just throw some out to you now. What about infants who are in a class? What kind of retainer will you have with your client? What kind of contingency fee arrangement is your firm prepared to take on to underwrite this kind of litigation? Those are just something to mull over while we get ready for the next part of the program. And we're going to spend, you may want to jot down your own individual questions. We'll try to tackle them in the panel. For me, I think that the big challenge is the same one that the Attorney General identified, and that is that we really need to spend a lot of time thinking about our relationship with our clients. The judges are going to have to spend a lot of time thinking about their relationship with counsel in front of them, and the judge's responsibility to people who aren't in front of the court, because part of this control that we've given the judiciary over the procedure is rooted in the need to protect absent class members. So that is my A to Z overview. I promised to also do Tim Ray's paper. Let me just make sure I'm on the schedule here. Until 10:45. Well, that's good. We've got until 10:45 to tackle the Tim's paper. And I told Tim when I was talking to him last night, and he was very sick. I told him that I would try to do justice to his paper, but I was also going to make a number of remarks about him during the proceedings. And he got a little bit nervous about that, and I just thought what I'll do is I'm going to make those remarks at the end of the program. That way when Tim has to buy the video of this, he'll have to watch the entire thing in order to find out what I said about him. Lloyd, don't give anything away. Anyways, Tim's paper is called Party, Party, Party. I'm sure that has absolutely nothing to do with the fact that he's not here. Tim is a deadly serious litigator, but he also has a flair for where the law came from, and a flair for watching the law evolve. And you'll see from some of the quotations that he selected in his paper that both at the beginning and at the end of it, that he's really a student of civil procedure. But what Tim has tried to do in this paper is to identify these other procedural vehicles that are available, the representative action. Remember, what happens with Rule 12 now? Will there be any need for it? Who will use Rule 12? Intervention, the individual proceedings, joinder and consolidation, and a test case. Now, it may stick out like a sore thumb. You think, well, why would someone spend any time talking, for example, about individual proceedings? But what Tim does with each of these categories in the paper is he identifies the relative advantages and disadvantages of using them. An advantage of an individual proceeding that's not a class action, and also an advantage of using Rule 12, is that all this judicial control and paranoia about, that some may describe it as, about protection of absent class members is avoided if you can stick with an individual proceeding. If you can stay under Rule 12 somehow, all of the burdens, if they seem that way, of a class proceeding can be left at the side. Also for individual proceedings, this is an issue that came up in the context of the Dalcon Shield cases in the States. The plaintiffs didn't want to be in a class. They wanted to have individual lawsuits. And it was the defendant, Robbins, that kept saying to the court, we need to be in a class action so we can get some efficiencies in the litigation. Also so they can, in some cases, try and cap their liability. Plaintiffs and their counsel said, we're very happy having individual claims. My client needs special attention. My client's got special needs. I got a special relationship that involves a contingency fee. And lawyers in some cases were saying, I stand to gain far more with an individual action on contingency than I do tossing this thing into one big class action. There's quite a struggle around that. But the point is that you're going to really have to look long and hard at whether or not the claim sitting in front of you, whether it is well suited to a class action, should actually be one, whether that's in your client's best interest. And that's where you're going to have to sort out this conflict that you may have, where it's a class action and you're going to have to explain the choices. Do you want to represent the class or not? And if you don't want to represent the class, fine, here's how your litigation will proceed. But characterizing the relative advantages and disadvantages of the class action to a client can be quite a challenge. On one hand, you're going to be able to say, if you're the representative, your disbursements are paid by the fund. If you're not, you pick up the tab on your own or the firm underwrites it. If you're in the class proceeding, you get access to this unique contingency fee arrangement. If you're on your own, you may not have a contingency fee possible. The client's going to have to balance that off. So anyways, we can spend some more time talking about that. But what you should zero in on in Tim's paper is the very articulate way in which he's captured the relative advantages and disadvantages of these other vehicles like intervention and joinder and consolidation. He reproduces all of the appropriate sections of the rules, Rule 6, Rule 5 for multiple defendants and respondents, and canvasses over the following pages their advantages and disadvantages. On page C30, he picks up the test case, which we shouldn't forget about, because if you can get everyone to agree to be bound by one case out of many going forward to test the water, again, you get to run the litigation without a lot of interference. And if everyone's prepared to be bound by the result, it may be the easier way to go. Just in wrapping up on Tim's paper, I just want to underline the point at which you're going to have to demonstrate to a court that you have thought out all of these relative advantages and disadvantages, and that's at certification. When someone stands up in front of a court and says, this class proceeding is the preferable way to solve the common issue because joinder's not appropriate for the following reasons, consolidation won't work, trial of an action's not the right way to go here, a test case we can't get people to agree, and so on and so on. And my client, and this goes to the question of how you've characterized the relative advantages and disadvantages of individual proceedings as opposed to a class proceeding, my client is prepared to be the representative plaintiff, to prosecute the action. We've got a plan, we've developed it, and here's what we propose to do. So it's at that stage that the court, and I suppose the bench itself will have to spend some time with these other alternatives. You're going to have to be able to satisfy the court that, that this is not just a way to solve the problem, it's the preferable way to solve it. So that, in a nutshell, is Tim's paper. I know I haven't done it justice. He spent a lot of time and effort on it. There's a lot of thought that went into it, and you may just want to spend some time with it. We're going to take a short break now so everybody can have a coffee and a muffin or something. Save up your questions because we definitely want to tackle them at the end. Every time we've done a panel like this, there was one in April of '91 put on by another organization, not the Law Society. And there was another one done in March of this year, put on by another conference company. And without fail, every time we get 30 lawyers in a room looking at this procedure, somebody says, what about this? And Andy and myself and some others, Terry O'Sullivan from Macmillan Bench, who was the Advocate Society rep on the advisory committee, we always end up scratching our heads for a few minutes and trying to figure out how to handle this particular kind of claim. So I'm sure it'll happen again today, and that's half the fun of going through the procedure. Anyways, I hope you're not exhausted hearing my voice. You're going to have to listen to me again over lunch, but let's take a break and come back and do the plaintiff's perspective on class proceedings, Bev Moore and Andy Roman from Miller Thompson.